All right, welcome back. Okay, very good. I'm almost done grading the midterms. I think I'll be done Wednesday or Thursday, but you'll definitely have them back by Thursday, one with the others. Just make sure you pick them up by Thursday. And the first round of appointments, I think, are on Saturday and on Sunday. If you haven't signed up for a time slot, please do. There are not many left. Might not be a choice time, but you have to sign up. Not optional. All right, questions? Anything in your mind?
Oh, yeah, I got a question.
Yeah, Marcos?
Yeah, so yesterday I came across an article about how in Sugarland, actually, where I live, they were finding bodies, like dead bodies from like back in the slave, like back in during the slave.
Oh yeah.
And because they were digging it up, and there's like people that work in the plantation and stuff. And the article was really long. I didn't really finish it. I didn't even really start, but I just the picture. But I read the title and looked at the picture. Like, but yeah, so I'm just wondering, what do they do with the bodies? Like, do they just burn them? Do I like? And what if I found one in my backyard? Like, I need to know.
I don't know. I don't even know where to start.
I can send you the article.
Yeah, you know what? Send me. I'll read it later. I can't even know. Just I'll answer. Let me send me the article. I'll read it, then I'll get back to you on Wednesday. Okay? Fair? Okay. I'll read the article. That's just the title. Oh boy. Any other questions? Okay. So we are starting now the final unit in Property 2. If you can believe it, this is what, class number 20? So we're basically almost done. And in the future, this entire unit will no longer be taught in property. It will probably be taught in con law or perhaps an advanced land use class. And we're still futzing with the breakdown. By the way, you know you're not subject to the new bar, but your colleagues will be. Okay, so our discussion today, and really for the rest of the class, focuses on the takings clause. And we've already discussed the takings clause in a limited context with respect to zoning. We described there's this relationship. If the government exercises police power, they don't have to pay. But if it's not the police power, then it's a taking, and you have to pay. So there's always this struggle, right? Are you in the taking bucket, in which case you have to pay compensation, or are you in the police power bucket, in which case you don't have to pay? If we look at the takings clause, right, I've highlighted 4 phrases. And they implicate 4 separate issues, right? It says, nor shall private property be taken for public use without just compensation. All right? So the first question is, what is property? Does it apply to only real property? Does it apply to personal property? Does it apply to property perhaps in your body parts? Right? The short answer is the court says all of the above. And the court has defined the phrase property very broadly to apply to real property, personal property, as well as even body parts. Remember, you ever see the movie Iron Man 1? And he said, he's property of the U.S. government. And I was like, no, it's a taking. But you know, I actually shot that in the theater. But there's a line in the movie Iron Man where someone goes, he's the property of the U.S. government. I'm like, no, that'd be a taking.
I think that's in the second one.
Was it in Iron Man 2?
Yeah.
Okay, close enough. But yes, I shouted it out. All right. So the first phrase is property. That's been interpreted fairly broadly. Okay? The second one, taken, right? Here we ask, has the government taken property? It's often called a taking, right? T-A-K-I-N-G. The government engages in a taking when they take your property. So the word take is used in a lot of contexts. The difficult line, which we'll discuss in class starting on Wednesday, is what is it to be a taking and when is it not? Our case today, Kilo, is very easy, right? There's no doubt that the government tried to take Suzette Kilo's home. There's no question in anyone's mind, right? It's a taking. But in other cases where they restrict how you use your property, for example, they say that you can't mine in a certain area. You can't mine for coal. Or the government says that you can't build a tower, which goes into your air rights. Or if the government says you can't build on your beachfront property, right? Those cases are tougher because you get to keep your property, albeit with a reduced value. And what happens when the government reduces the value of your property? Is that a taking? We'll spend a lot of time on that. Okay? The third phrase is public use, which is really the crux of our discussion today. The government can take your property as much as they want, but only for public use. Right? Does that impose any meaningful limitations on what the government can take? Well, that's the subject of Kilo, which we'll discuss today. And the final provision, which we won't talk much about, maybe I'll mention it later today, is the just compensation clause. Right? If the government wants to take your property for public use, they have to show you the money. Right? But what does just compensation mean? Does that mean fair market value? Does that mean something more than that? For example, let's say you have to hire a real estate agent to buy a new house. You have to hire a moving company to move your stuff. Let's say you have sentimental value in the house. It's a really important piece of property to you. The short answer is none of that matters. Just compensation generally refers to the value of the property, and after that you're on your own. And the topic of eminent domain is one that often strikes people as inherently unfair. And it reminds me of our first lesson this semester, which was adverse possession. Right? How is it fair, right, that this guy just squats here and gets the property? Or how is it fair that the government can say, we're taking your property, here's some money, go away. Can't do anything about it. So it's a very tough topic, and I hope to maybe explain why it's important. But our focus today is on the public use clause, and we'll focus the rest of the semester on the takings clause. All right, so any questions on that at a high level? Yes?
So you said that the just compensation is just the value of the property?
It's usually the fair market value. So if someone were to try to buy your house on the market, what would they pay for it? But again, that doesn't include things like sentimental value, right? Because some people just don't want to sell their property. They like it. They like living near the beach, right? They like living near the water, whatever happens to be. They don't want to move. The just compensation doesn't take into consideration your private valuation of the property. It only looks at whatever a public market would generate a price for. Make sense? All right, so let's try a question. And this will get us thinking about our topic for today. And here's your question, right? So the city of New London, Connecticut took Suzette Kilo's home for a public use. Okay, true or false? Okay. All right. I think most of you got there. Who am I up to next? Where am I? Oh yeah, Shan, thank you so much. All right, what do you think the answer is here?
I put true.
Okay, tell me why.
Because they purchased the land to sell it to other private owners to create jobs.
So they took Suzette's property to sell to someone else who would create jobs. Is that a public use?
I would say yes, because it benefits the public overall.
Can
And if they put like a shopping mall on there, then people can go and shop, or a gas station, I guess, or a grocery store or something.
Can it be used by the public?
Yes.
So I can just walk into a Pfizer research facility and just chill in the lounge?
Yeah, you probably could, but
Oh, I can't. I got a story for you. Brittany, what do you think?
I think it's false.
Okay, tell me why it's false.
I mean, it goes to what you were just saying. It's more of a broad or global approach of public use, that it can promote economic efficiency throughout the community, things of that sort, but it's not public utilization.
Ah, so you equate use with public utilization. That's how you define it.
Yes.
Megan, what do you think?
Well, at first I agree with Cheyenne,
Uh-huh.
but now I agree with Brittany.
Well, what do you think? You tell me why.
Just looking at the broad use of the property.
Uh-huh.
Who can access it? Can anyone access it like it's a public park?
Ah,
Or
okay.
is it
So let's say they made a train station there, right? Or a railroad, right? Do you think the position would be a little bit different?
Yes,
Why would it be different if it was a train station or railroad?
because everyone has access to that. It's not restricted based on who you are, what credentials.
Yeah, we call those common carriers, right? Right. So let me take a step back. It's so funny. Cheyenne said, so I actually visited the Kilo site in 2012 or 13. I can't remember the year. I was speaking at a conference at Yale, which is in New Haven, which is maybe a 2-hour drive from New London. It's like, what the hell? So I drove out to New London, Connecticut. And I wanted to get a video of the area near Suzette Kilo's home. Now, this is a Google map satellite. And as you can see, the entire lot is empty, right? There's nothing there except for a little thing in the corner. I'll mention that in a bit. So, this genius, right? So I drive downtown to New London, and my first stop is to actually visit the Pink House, right? So Suzette Kilo had this very famous pink house right by the water. Long story short, she lost her case. So they actually disassembled it plank by plank, and they moved it. I don't know how you do this, but they moved it plank by plank across town, and they rebuilt it. Right, so they actually rebuilt the house. So I found out the address, and I walked up, and I was about to knock on the door. As a little sign says, "Do not knock the door if you learn a Kilo." So I think they sold it to someone else, but still pink. So I think there was a covenant to keep it pink. So I took some pictures, right? So I said, okay, let me drive to this area by the water where her house was. And this was in 2013, so I had my video camera in one hand, and I was driving with the other. I'm like, do 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 do, and I wasn't really paying attention where I was going. And I made a wrong turn. And I accidentally pulled into the General Dynamics parking lot. Now, General Dynamics is a military contractor. They do a lot of, Mike's laughing. And you're not supposed to go to these places. So I pull in, and you can imagine I'm this guy in a suit with a freaking video camera recording. And I'm like, oh no. And then this Jeep pulls in front of me. I'm like, oh, this is bad. And this huge guy gets out. He's like, what are you doing? I'm like, oh God. I'm like, I'm a law professor. I am recording a film of a very famous Supreme Court case in this neighborhood, and he has no idea what the hell I'm talking about. I'm like, oh God, this is really bad. So he's like, give me your license. I'm like, oh crap. So I give my license, and I said, look, I'll show you my memory card. I'll delete my whatever I have, and then you can let me go. I was like, fine. So that's why I don't have video of it, because I had to delete the memory card. But I got close enough to get pictures, and the pictures I was able to keep. So the actual lot where Kilo's home is, her house was somewhere around here. You can see it's this huge lot. Her house was on the corner right around here. Okay? The Kilo case is, 2005, right? We're now in 2018? It's still an empty lot. There's still one building that remains on the corner, and that's another funny story there. It's called the Italian Dramatic Club. What? Yeah. It's a private men's club on the corner of this lot. Now you might ask, Josh, why is the entire lot vacant except for this one, building in the corner? Well, I'll tell you the story there. It was a fairly influential club. A lot of the local politicos went there. And when the entire process of negotiating the comprehensive plan, sorry, the scare quotes, the comprehensive plan was being developed, the owner of this club, a guy named, I think, Valenti, obtained assurances that they wouldn't take his property. And they got in writing that no matter what happens to this area, Fort Trumbull, they would not seize his club. So that's why it's still there. Now, I got another story. So after I basically got pulled over and this guy scared the crap out of me and let me go eventually, I pulled my car into the Italian Dramatic Club parking lot and I started taking pictures. And these two huge guys in pickup trucks come for their Sunday morning meetings. I was not having a good day. So I had to get the hell out of there real quick. So my picture's actually fairly blurry there. I got some good pictures. But that's still there. And the reason why I always mention that that story, that's the general dynamics, and that's where I got in trouble. So it's right next to it. The reason why I mention this is when you have eminent domain, the government invariably needs to make decisions about which property you're going to take, which property you're not going to take, and who gets the benefits of those properties. And at least in this neighborhood, they decided that Suzette Kilo and some of the other homeowners would have their property seized. And other people, like the Italian Dramatic Club, they'd keep their club just fine. Why is this important, right? Because the court in Kilo decided what level of scrutiny they would use to review the taking. And long story short, in Kilo, the court said, we are not going to scrutinize the wisdom of why the government took this corner over that corner. That's for the government to decide. Now, here we are almost 13, 14 years later, and Suzette Kilo's lot is still empty. Pfizer, which was involved in this case, we'll discuss that in a couple minutes, ultimately acquired Wyeth, right? Yeah, I think they're the pharmaceutical. And they said, you know what, never mind. We don't really need any research facility there. They just moved out. They packed up and left. So the area is still empty. And it wasn't really ever developed. So this entire case about how important it is to develop this area and how it will generate the tax base of the city, it never came to fruition. One second. And if you actually listen to the oral argument, the lawyer for New London tells the court, Your Honor, by 2010, we have all this office space. It's going to be amazing. And then the court says, well, we don't have to require any degree of certainty, but we're confident this is good. And it didn't quite work out that way. Yeah.
So since there's nothing there, like since they didn't build it in a certain time, why couldn't she get it back?
The city probably won't sell it to her.
Even though there's nothing there, though?
I don't know in Connecticut if you can adversely possess against the government. I don't know the answer, but I can tell they police trespassing very strictly in this block. Take it from me. I suppose it'd be fitting if Kilo wanted to buy the lot back from the city. I don't know if they'd sell it to her. They're probably still pretty bitter about this. Kilo moved out, which is what I was trying to convey. The pink house, they moved about a mile or two away, but as best I can tell, Kilo doesn't live there anymore. Someone else does. Again, they have the sign saying, like, don't ring the bell if you want to learn about Kilo. It was like, go away. We don't care about you. A movie was actually made about the Kilos. Did anyone see it, the Kilo case? I really should have seen it. I'm a property professor, but I didn't see it. I feel a bit embarrassed, but it came out about 4 or 5 months ago called The Little Pink House. Anyway, I didn't see it, so I can't speak about it, but I'll see it eventually. I don't watch lots of TV. I don't have time. Okay, so everyone get the general gist. Now, going back to our question, right? Our question which we led up today. The court held that there was a public use. And the way that Justice Stevens got to the holding that there's a public use was by reading public use in a very broad fashion. I think Brittany used the word global. Is that the word you used? Global, yeah, I think I like that word. How? By equating a public use with a public purpose, right? What the majority does in Kelo is they equate a public use with a public purpose. So as we go through our lecture today, keep in mind that under current doctrine, the phrases public use and public purpose are synonymous. Okay. All right, so any questions? I think, Tacey, you're next? Yeah. Tacey, why don't you give me just the general facts in Kelo, please?
So you had the city of New London, and they were economically depressed because all of the shipping industries and stuff had left.
Mm-hmm.
And so they kind of wanted to revitalize the area. So they created a development plan to do this. And the plan was to take the property and give it to Pfizer so they could create all these new jobs and have this booming economy. And Kelo was one of the houses they were going to take. And so her and I think 9 other defendants were suing.
Okay, very good. So, Christiana, let's just walk through the sequence here, right? Did the city run right away and say, we're going to take your house right away, or was there a process that came before that?
They thought they were going to try to get people to like pay off some people, and then they were going to go through eminent domain.
Well, first they want to do a voluntary buy-off, right?
Right.
So, Christiana, what's the problem if you say we want to voluntarily make an offer to buy your house, right? Why might that work?
Because the first person will, like, say you pay them like $1,000 or something, and then the next person will raise it, and then it'll keep going up, and then one person will hold out.
Exactly, right? So Christiana discussed what we often call the holdout problem, right? The holdout problem. Why is it called the holdout problem? Because someone will always hold out. If you have, just make it easier, 10 people on the block, and let's say person number 1 sells for $1,000. The person who says, you know what, I'll go for $2,000. And the person 3 says $5,000. And the person number 8 says $20,000. Then you get to person number 10. He's like, screw it, I'm not selling, right? Can you build, a research facility with the house still in the middle of the lot? Well, apparently you can with this guy, but just in theory, right? If Kelo's house was just here in this corner, it was right around here, I think, can you still build your facility? So the traditional reason for eminent domain is to eliminate the holdout problem, right? It's to ensure that when the government needs to take property for public use, they can get the property they need. I mean, imagine an easy example, right? You need to build a railroad, common carrier, and the railroad has to cross this one piece of land, right? It's the only place where it's safe to build a railroad, only place. Let's say the person says, not going to sell my land. Then you can't have your common carrier. Or let's say you need to build, I don't know, a hospital or a military base in a very specific strategic location. A school maybe, right? Eminent domain breaks the holdout problem because you can always get the piece of land that you need. Right? So there's nothing wrong in the abstract with eminent domain. It's a power that's been exercised for hundreds of years. But critically, when you want to exercise it, you got to pay for it. Why this case became so controversial was because of the nature of the plan. Elena, tell me a little bit more about this comprehensive plan that the city put together. Tell me a little bit more about it, please.
For a while, when the government was situated, they were thinking about what they can do, and they had a couple of different plans, and finally they come up with some. I think they call it comprehensive.
Comprehensive, yeah. Tell me about it.
So they hired a private nonprofit to assist city in planning the economic development, and they authorized a certain amount of money in the bond issued to this nonprofit. It's like 5.35 million and 10 million bond issued to this. So pretty much what they wanted to have this piece of land, and they wanted to have Pfizer to move in and have this research facility. They needed it to be next to the water, and Yeah, so Pfizer said that they would build a 300 million research facility.
So was this basically, and let's just be very precise, was the purpose of this taking to give it to Pfizer? Was that the purpose of the taking?
Are you asking my opinion or what the court said?
Well, okay, I'll ask you both. All right, what do you think? And then what would the court say? Maybe are those answers different?
Well, the court said that they look at all the testimonies and witnesses and records between the parties, and they said that no, actually the plan was before the Pfizers had come up to the site, so they just wanted to have, pretty much the people to do better.
Yeah. So according to the court, what was the purpose of this plan?
The purpose was to make the people living around, pretty much just to develop economy.
Yeah, to improve the tax base, right?
Yes.
Okay. Now, what do you think?
Well, it kind of looks a little fishy. I think it's
Fishy. Yeah. Yeah, I think she's right. So, but I want to be very clear here, right? It's very often said about this case that the purpose of the city was to give the land to Pfizer, right? And that might be the effect of what they're doing, but they said in court, and they were very clear about this, that their purpose was not to give the land to Pfizer, right? Their purpose was to increase the economic development in the city, in Fort Trumbull. Now, if the way to get to that economic development was to give it to Pfizer, well, so be it, right? But this makes a difference. There's a very old principle of law in a case called Calder versus Bull. Calder versus Bull. It's quoted, I think, in the O'Connor opinion. And it says, if the government takes from A and gives to B, that's not law, right? That's unjust. It's a basic principle. You can't take from A and give to B. So New London says, wait a minute. We're not taking from A and giving to B. We're taking from A so A can have more and a better community. And maybe B will get it eventually. I know you're chuckling, whatever, but there's an important distinction. The court draws this one very carefully. There's also a lot of facts that aren't in the opinion. That New London heavily lobbied for this development plan, that New London gave like a loan to the corporation that took the property, like $100,000 interest-free loan, right? So there's a lot of backroom dealing here, right? This wasn't a case where they had like an open bid for different companies. Basically, Pfizer said, "Want to build?" They're like, "Okay, how can we help you?" I mean, we can be candid enough about what happened here. So initially, they asked Kilo and the other neighbors in the block to sell. They refused. They didn't want to sell. If you look at the pink house, it's hard to see, but the sign says "not for sale." You see that you see a for sale sign that says "not for sale." That's their sign. Okay. So then after Kilo declined to sell, the government instituted what are called condemnation proceedings, or eminent domain. They're used the same way, right? Eminent domain or condemnation. Now, when you hear condemnation, you think, oh man, it's like a dilapidated house, right? It's falling apart, it's not safe. That's not what condemnation means. Condemnation refers to using eminent domain, the taking power. And if you look at this house, it was a beautiful house, right? There was no allegations it was in bad shape, right? There's no allegations it was run down or falling apart, or it was infested or animal problems, right? Actually, no, there are feral cats who live there now. There's actually a bigger animal problem now. But there's no allegations. There's no blight. So this goes to court. And Kilo argues that the taking violates the public use clause of the Constitution, of the Fifth Amendment. And the trial court actually split the difference, and they gave some relief to some of the property owners. But then the Supreme Court of Connecticut reversed and found that this taking was in a public use. So the case goes to the Supreme Court, and it splits 5-4. And Justice Stevens writes the majority opinion. Hannah, can you please walk me through Justice Stevens' opinion?
He says that since the economic development constitute or qualifies as a public use, therefore, or a public purpose, therefore it satisfies the public use requirement.
Very good. So, Hannah, there are a couple major cases that the court cites for this. I want to talk at least one of them, right? There are two major precedents that Justice Stevens relies on to find that the development here was a public use.
Are you asking?
Yes, I'm asking you.
The Hawaii housing in Midriff?
That's one of them. What's the other one?
Midriff?
Midkiff, yeah. And what was the first one? Hawaii Housing Authority versus Midkiff is the second one. What's the first one?
Is that Berman?
Berman. Very good. Yeah, very good. Thank you. Right. So when we're dealing with Supreme Court cases, you have to keep in mind there's precedent. And the Supreme Court doesn't write on a blank slate. And there are two important decisions, one from the 1950s, one from the 1980s. The first is called Berman versus Parker, 1954. I think it's 54. Check me on the year. And the other one is Hawaii Housing Authority versus Midkiff. Was that 81 or 82?
84.
84. Okay, sorry, I was off by a couple of years. I should note that year too. So you have Berman, and then you have Hawaii Housing Authority versus Midkiff. And these are two important precedents. Now, when you're ever arguing before a court, right, and the judge asks you, should we overrule some precedent, right? The answer is almost always no, you should not, right? Because if you say, Your Honor, you should overrule a precedent, you're probably going to lose. Not always. I'm sure there are exceptions, right? We have exceptions. But generally, courts don't like overruling their precedents. Here, Kelo really wanted to overrule those cases, but you couldn't ask for that. Other people did. But because the court was bound by Berman v. Parker and Hawaii Housing Authority, she was very unlikely to win, unfortunately, I think. I don't know. Maybe they should have asked to overrule. It's a very tough call, because you're damned if you don't. But anyway, they thought they could thread the needle. All right, Anthony. So tell me about the Berman v. Parker case. Very, very important case from the 1950s.
I would say the Berman v. Park case essentially.
Parker.
They upheld the takings within the community in Washington, D.C. I mean, the neighborhood just got essentially bad that its dwellings were beyond repair. And essentially, I mean, the Congress had determined that the neighborhood had become detrimental to, say, public health and safety. And
Anthony, was every property in the neighborhood in D.C. blighted? Was 100% of the block blighted?
Incorrect.
I was asking a question. What was it?
No. The entirety wasn't blighted.
So some parts were okay, and some parts were not.
Correct.
Then why couldn't the government just take the good parts and leave the bad parts alone, or seize the bad parts and leave the good parts alone?
I think they wanted to treat the neighborhood as a whole.
Very good. Yeah, very good, very good. So Berman was an important case in the 1950s where you had a neighborhood in the District of Columbia in D.C. And parts of it were admittedly pretty run down, right? Parts of it were not in the best of shape. And other parts were fine. And there was an owner of a hardware store who said, I don't want to have my property taken. My store's in good shape. It's in good business. And this is an opinion by Justice Douglas. And you remember Justice Douglas, who wrote Village Bill Terror versus Boris, right? Where he referred to apartments as parasites. And you have to keep the clean air, right? So Justice Douglas wrote this very deferential opinion where he basically said, as long as the government decides that this is the right property to take, it's not the role of the courts to second guess that, right? The courts are not going to second guess where the elected branches decide to seize property. It's not our decision, right? That they have their plan and they have their mission, and it's not for the courts to intervene. So there's some very broad language in Berman v. Parker, which upheld the use of eminent domain effectively to improve community welfare, right? It wasn't strictly about improving the tax base. It wasn't exactly the same facts in Kelo. The idea was you can use eminent domain to improve the well-being of a neighborhood, even portions of the neighborhood that are not in bad condition. And that's important. All right, so any questions on Berman? All right, so James, our next case from 84, year I was born, should know that year, is Hawaii Housing Authority versus Midkiff. Tell me a bit about that case.
I think in that case, I think the state was basically trying to rectify imbalances in ownership of property.
Where was this taking place?
Hawaii.
Yeah. So let me take a step back. Do you remember last year we did a case in family law, not family law, but marital property, Sawada versus Endo? This was a case from Hawaii where you had the couple that got into a car accident and they didn't have insurance, right? And they had this like fraudulent conveyance to their son or something, or to their sons, because they realized if they lost the case, their property would be taken. Right? They actually own property in fee simple. Remember this? So Hawaii has a somewhat unique situation, right? There's not a lot of property, right? It's a bunch of small islands. And in the 1980s, they had a crisis. Almost no one owned their property in fee simple, right? Almost all the fee simple is actually owned by several wealthy families. They call this the oligopoly, right? Ownership by a wealthy few. So Hawaii has this idea, aha. If you are currently renting property from one of these oligops, I don't know, one of these wealthy people, right? We're going to use eminent domain to transfer the fee simple from the landlord to the tenant. Hot damn, right? Robin Hood. We're going to seize the property from the wealthy landlord and transfer it to the tenant in fee simple. And you pay for it. So basically, it's a forced buy. The landlord had no option, could not decline it. Unsurprisingly, Mitgiff, one of the property owners, challenged this taking. He said it's not in the public use. You are literally transferring it from A to B, literally from the landlord to the tenant, right? And so, Andres, what happened then in Hawaii Housing Authority?
The court still upheld the statute.
Okay, tell me why.
I think they said they weren't just transferring it from A to B, and it was not just for B's private benefit.
Right. What was the purpose of the program?
It was to reduce the concentration of land ownership.
Very good. So again, if you describe the public use much more broadly as a public purpose, here reducing the concentration of fee simple ownership, then it's fine, right? It doesn't matter if individual people do benefit. What matters is that there's a broader purpose that the taking is designed to achieve. Now, what's especially noteworthy is who wrote Mitgiff is Justice O'Connor. And here she is dissenting in Kelo some 20 years later. Justice Thomas wrote a separate dissent where he said he'd overrule Mitgiff, he'd overrule Berman. Justice Thomas doesn't have a strong sense of stare decisis. It's not his thing. But Justice O'Connor's in a bit of a twist because she basically wrote Mitgiff some years earlier. She distinguishes, we'll get there in a few minutes. So the upshot is you have Berman v. Parker saying that you can seize every aspect of a community, even if only parts of it are blighted, to improve the community. And then you have Hawaii Housing Authority, which says that to promote the economic well-being of an area, to have more fee simple ownership, you can literally seize it from the landlord and give it to the tenant. So after Mitgiff and Berman, Kelo was not much of a surprise. It came as a surprise because people didn't realize these old cases still had any effect. But if you were a property student, it wasn't that much of a surprise. I think I took property in 2006, maybe 7, so shortly after Kelo was decided. It was a huge, huge deal, right? Because people didn't know that the government can take your property for improving the tax base. People just didn't know that. But as a legal matter, it wasn't very surprising that the case turned out the way it did. Right? So given Berman and given Mitgiff, what was Kelo left to argue? Kelo argued in court that economic development should not be a public use, right? That eliminating blight might be a public use in Berman, and reducing oligopoly might be a public use in Hawaii housing. But Kelo argued that here, if the only purpose is increasing tax dollars, then that's not enough, right? Because you can always increase tax dollars. To use Justice O'Connor's famous analogy, if you convert a Motel 6 into a Ritz-Carlton hotel, you're always going to increase the tax base, right? If you take a mom and pop shop and make it into a Costco, right? You're always going to increase the tax base. So this is a rule that always be satisfied, that there's no limit. And so Brandy, how does Justice Stevens respond to this argument that there's really no limit, that basically any property can be taken given this public purpose test?
It says that, well, using the three pass spaces, 2 pass spaces that they use, that it's the economic benefit is enough to satisfy public use.
And is there a role for the courts to scrutinize this?
Excuse me?
Is there a role for the court to scrutinize the taking?
No, it's for the government.
Yeah. Yeah, very good. Thank you. Yeah, so at this point, Justice Stevens says, well, yeah, it's probably true that property can be taken very easily, but that's for the political process to worry about, not us. Now, the strange aspect of this case, at least strange to this con law person, is that you have a text of the Constitution. It says public use. And you read public use to be very broad, meaning public purpose. It basically kills any teeth in the takings clause. And again, I don't think this is Justice Stevens' fault. I think he was standing by precedent, and I think that's a valid excuse. But what's left of the takings clause then? If anything that can generate economic development is a public use or public purpose, then the only check on this process is politics, right? If you are the owner of the Italian Dramatic Club and you can twist a few arms and get your property saved, then you're fine. If you're Suze Kilo, or someone's been living in your house for 50 years, whatever, you're screwed. So the upshot of this, and why this case always rubs me the wrong way, is the court says that with respect to the protection of a constitutional right, we'll leave it to the political process. And generally, it's the exact opposite. Indeed, with lots of unenumerated rights, rights are not written down, the court says we can't trust the political process with these unenumerated rights. But you have a right that's actually written down. It's enumerated. It's right there in the Bill of Rights. And they give it what's effectively a rational basis review, saying we're not going to look at it. We're not going to challenge it. As long as it's not obvious, right? They make up some excuse why they're doing it, it's fine. So Kilo doesn't fit in with the normal hierarchy of the Bill of Rights, where rights are usually considered at a much higher level. Here, it's more or less whatever. It's not that important to have your house. Okay. So any other questions then on Justice Stevens' majority opinion? Any question on the Stevens majority? No? Okay. Who's next? Rochelle, let's talk about Justice Kennedy, right? He was influential, not anymore, and now his opinions matter very little. Truly, they do. I think his opinions will fall out of casebooks at a rapid pace. I'll see to it myself. But I mean, even now we're recording a video about Hobby Lobby, and we were saying, did we put Kennedy there? Like, yeah, we'll admit him. It doesn't really matter what he thinks now. His opinion only mattered because he was a fifth vote. Otherwise, it's not there. It's not like a Holmes or Brandeis or Cardozo or Jackson. You'll study him for 100 years from now, right? No one will be reading Kennedy 100 years from now. It just will not be happening. We won't. He was there because he was a fifth vote. That's what. No one reads O'Connor now. She was there because she was a fifth vote. That's why she was there. Brennan, right? How many Brennan cases we read? We read him. He was fifth vote. Anyway, Rochelle. So let's at least focus on Kennedy for now. What's Justice Kennedy's concern? Right? Why does he write something separately?
I think his issue was the suspicion that people could take other people's property and just give it to them for economic benefit without there being some showing that this was for public use.
Very good, Rochelle. Why is Justice Kennedy not concerned that this is such a case, that this is simply a pretext that they're taking it from A to B? Why is Kennedy convinced that he's not worried about Kilo's taking?
I think it's because the trial court, they found that the motivation for the plan was not to give it to the private eye.
Yeah, but how do we know what the motivation was? Like what? Right. I mean, how do we know what the motivation was of the city, or actually the corporation?
Well, they said that they were motivated by the desire to aid others.
Okay.
And they developed the plan before he came.
Okay. Okay. Plan. Right. That's what I was looking for. Thank you. So Justice Kennedy says generally, right, we should defer. We should use a rational basis review. Did you study Williamson v. Lee Optical in con law? Right. In Williamson v. Lee Optical, right, the court can simply presume that the action is constitutional. We call that a presumption of constitutionality, right? That Whether or not the reason given is real or not, we don't really care. We'll just presume the government's acting lawfully. But here he said there's no evidence that this was intended to protect or benefit a particular party. Right? But he says there might be some cases where you have a more narrowly drawn category of takings, where there's a risk of favoritism. And in those cases, you have more demanding scrutiny. But we don't have to worry about that here. Why? Because there's a comprehensive development plan. And because that plan and the city comply with various procedures, we don't need to be suspicious. So, Brooke, what lesson does this then teach governments that want to use eminent domain? How do they bulletproof their taking so they don't have to worry about some court finding it unconstitutional?
Make sure it's not singling out a particular class of people.
And how do you go about doing that? Right? What can you do to make sure that Justice Kennedy's happy with your eminent domain condemnation scheme? What do you have to do? Josh?
Make sure you have a well-thought-out, comprehensive plan.
Comprehensive plan. That's all you need, right? Now, let me tell you something. These plans are not very comprehensive. They're not really plans, right? They're pretty, it's like, well, if we build it, they will come, right? If we seize this land, then magically $300 million will funnel into our community, and we have this idea, we'll have office space here and whatever there, right? As long as you have some sort of plan, and this is not just ad hoc, right? Saying, well, we're taking this to give it to Pfizer, you're fine. In other words, if you do a modicum of work to paper over your plan and give a reason why you're doing it, then you're fine. And the courts won't scrutinize it. So the question is this: how dumb do you have to be to take property without having a comprehensive plan, right? How dumb do you have to be to violate the public use clause? Any reasonable effort to put together some plan under the Kennedy standard will give you a rational basis review, in which case the court will not scrutinize your actions. So the upshot of this is what Justice Scalia used to call the stupid staffer rule, right? As long as you don't have a stupid person working on the case, you're fine, right? If you have a modestly intelligent person who can come up with some extravagant plan, you're probably fine. Now, Matt, is there any requirement that there's a likelihood of success that this plan might actually succeed?
No.
Right? Do you need a written commitment from Pfizer that they'll build X number of office plazas, whatever? And what happens if 10 years later Pfizer walks away and nothing happens?
The taking's still valid.
Right. So again, it's all conjectural, right? It's about conjecture, speculation. If you are a government official who say, well, we think this is going to happen, well, that's good enough for the court. The courts aren't going to scrutinize that with any sort of specificity. And indeed, nothing was built, right? I mean, that doesn't disprove the taking, right? Maybe Pfizer could have wound up building a facility there, but they didn't, and the lot's still empty a decade later. It'd be a good idea if Kilo bought it back. I kind of like that idea. I don't know if maybe the city will sell it to them. You really need the money. They're that depressed. I don't know. Build a museum or something. Beautiful location, though, right by the water. I mean, a gorgeous, gorgeous spot. Yeah, Anthony?
Yeah, not to look too far ahead, but I also did take a look at the dissent and did also notice a justice on there, Justice Scalia, was on that opinion. They touched upon the private use, public use, and the fact that they said if they went along with this decision, it would kind of blur the lines. Would you say that it's separated between that private and public is a view that you most strongly hold on to?
Are you asking my opinion? I don't know what you're asking.
Yeah, I was asking your opinion because I was reading the dissent and I was thinking this might be a leaning that would say Professor Blackman would.
You never know what I'm going to think. Well, I mean, look, let me take a step back, right? Kelo is somewhat of a unique case where usually, 5-4 cases, conservatives tend to like it and liberals hate it, or liberals tend to like and conservatives hate it. This case was unique in that almost everyone hated it, right? Across the spectrum, right? You have, Rush Limbaugh and Jesse Jackson the same side of an issue, which is fairly rare. But this was an issue that had a wide backlash to it. People said, how can it be that the government can take my property in order to increase a tax base? So in the aftermath of Kelo, and actually Stevens mentions this, Stevens says, well, even if the federal constitution doesn't provide much protection, the states can give more protection. Which is, again, strange, because usually they don't say that in any other right? They say, well, free speech is nice, but the states can give more protection, right? You don't see that. Usually the federal constitution gives more protection than state law, but not always. But indeed, after Kelo, a number of states actually enacted various reforms to strengthen property rights. My professor, Ilya Soman, who was my property professor, wrote about this very early on. The downside is most of these reforms were not very effective. For example, a lot of states like Texas said you cannot use eminent domain for economic development. Right? That's not a valid public purpose. Great, thumbs up. But Texas still permits eminent domain for blight. And blight can be defined as poor community, right? Not generating enough wealth. So a lot of these reforms didn't do much on in reality. But the upshot is that they drew attention to the fact that these takings go on. And I think they made governments less likely to use eminent domain for economic development. I think if anything Kelo did, that's what it raised public awareness that this was actually an issue. Brittany?
We didn't touch on it completely. I think it was brought up, like whether or not Suzette that she would be able to acquire this land back. Does the claim lie if the government did not use it for that purpose?
No backsies, right? It's fee simple for the government, right? Even if they took the property on false pretenses, which I don't think they did, but let's say they were false pretenses, the taking is still valid. She lost her entire bundle of sticks. So at that point, would the city sell it back to her? I doubt they would. Right? In other words, you can't challenge the taking saying, well, you promised $300 million and whatever, and it didn't happen, so give it back. That's it. You don't get it back.
Thank you.
Yep. Anthony, did I answer your question?
Yes.
Okay. So let's go on to the O'Connor dissent. Yeah. So give me the O'Connor dissent. Describe it for me.
Says that economic development is not a valid justification. Take people's land that's going to erode in private use and public use.
Okay. How does Justice O'Connor distinguish this case from Hawaii Housing Authority, which again she wrote 20 years earlier? Well, describe it. I think you're on the right track. Tell me a little bit more. How does Justice O'Connor, by the way, she's quite ill now, so please keep her in your prayers. She's almost 90. She had this very, very powerful statement where she admitted she has dementia or perhaps Alzheimer's, and she's losing her faculty, so she withdrew from public life. She has a very, very sad story. In 2005, her husband came down with a case of dementia, and she retired from the court early to take care of him. She left the court. I mean, she's still in her prime for a number of years. And then she was replaced by Justice Alito. The sad part is, shortly after she left the court, her husband's memory loss accelerated, and he actually forgot who she was very quickly. And my grandpa had the same with memory. It goes quick. And he actually totally forgot who she was and didn't want to talk to her anymore. And he actually started dating someone else in the home. Is really, so she's had a remarkable life. I always give this my spiel in con law, but Justice O'Connor was in the same class at Stanford as Justice Rehnquist was, and they actually dated briefly. He, I think, was graduated first in his class, and she graduated, I think, third in her class. He got a clerkship in the U.S. Supreme Court, and she didn't get a job at all. It was a very different field back then for ladies. And basically people giving her a job as legal secretaries. And she graduated third in her class at Stanford Law School. And eventually she found her way into Arizona politics and was put on the Arizona Court of Appeals. And then President Reagan put her on the Supreme Court in, was it 81 or 82? So yeah, she had a remarkable life, very powerful person, but she's not in good spirits now, so just think of Justice O'Connor a bit. Anyway, who was I? Yeah, Reed. So the question asked is, how does, with that wind up, right? How does Justice O'Connor distinguish her opinion in Midkiff from her opinion in Kelo?
She discusses the percent owning Hawaii at the time. For example, 47% of Hawaii was only owned by 72 private landowners.
Okay, why does that matter?
To try to disperse the wealth, I guess.
But why was it problematic that so many, or so few people own so much property? Why was that a problem? Right. What? Reed, let me ask this question. What did Berman, the property in Berman, share in common with the property in Midkiff? Right. Why do O'Connor think those facts were different than the facts presented in Kelo?
I'm not sure, to be honest. I had a trouble distinguishing between Midkiff and...
Okay, Ron, you want to take a stab?
She talks about how both of those cases were an inflicted affirmative harm.
I think Austin alluded to this a minute ago. Okay, keep going.
And how in Berman, there was the blight that was the resulting in extreme poverty, but in Midkiff, the oligarchy resulted in extreme wealth.
Yeah. So here's how Justice O'Connor tries to distinguish Berman and Housing Authority. I don't know if it's a perfect distinction, but she tries. She gives it a go. Right? She says, well, in Berman, you had blighted properties. That's an affirmative harm. And in Hawaii, you had this oligopoly, which inflicted an affirmative harm. That the mere act these properties existed harmed others. Right? You had blight, and you had a concentration of wealth. That rule, I think, works better for Berman than Midkiff, but I'll just give her this much for now. In contrast, Suzette Kelo's Little Pink House wasn't bothering anyone, right? There's no allegation that it was blighted. There was no allegation it was a concentration of wealth. People had their own homes. They didn't, there was no problem with fee simple. The only reason why they chose to take Kelo's home was because it wasn't generating as much revenue as something else could have, right? So she tries to distinguish Berman or whatever, and at one point she says there's some errant language, right, in Berman and Midkiff. Errant language that's unnecessary to the holding, dicta. It's like, oh, come on, you wrote this. Give me a break, right? Because she actually wrote in Midkiff, that the police power is basically equated with public purpose, right? That if the government wants to use its police power, it basically can extend to anything. There's no limits. She probably regretted that one. And she's like, yeah, just kidding, right? Only a Supreme Court justice can take back in their opinion. We can't do that. No one else can. Justice Thomas, in contrast, said screw it over both cases, which is probably more of a consistent position. Okay. But in the end, Justice O'Connor writes that any property may now be taken for the benefit of another private party, but the fallout from the decision will not be random. The beneficiaries are likely to be those citizens with disproportionate influence and power in the political process, including large corporations, development firms. As for the victims, the government now has a license to transfer property from those with few resources to those with more. And the founders could not have intended this perverse result. All right. That's Justice O'Connor. And also, Justice Rehnquist was quite ill at this point. I think he died, oh God, a couple months after this, maybe 2 or 3 months later. So he was very ill. He did not participate in oral argument. He joined Midkiff as well, but he didn't even write anything at this point. His career was basically over. He did not make it past September, if I remember correctly. And if you actually listen to the the announcement of the opinions, he sounded really bad. It was quite bad. Okay. All right. All right. So any questions on Justice O'Connor? Let's see if I can play this.
The opinion of the court in Kelo versus the City of New London will be announced by Justice Stevens.
He could barely even breathe at that point. He had really bad cancer. I hadn't listened to this till recently, but he was not good at this point. He had to deliver one of the opinions from the bench. It was actually hard to listen to. All right. Anything else on O'Connor? All right. Jake, let's talk about Justice Thomas, right? Walk me through Justice Thomas's opinion.
He basically said that the whole majority gave the law tradition of holding private property rights, that protecting private property outweighs public necessity in the framework of the Constitution.
Keep going. You're on the right track.
He said that the majority's definition or use of the public use requirement of the Fifth Amendment waters down the significance of the clause being use as eminent domain power, basically.
Okay. Very good. Very good. So, Justice Thomas, again, this is why this case should be taught in common law. Did you do this in common law? No, it should be done in common law. It's not a proper case. There's no. I've mentioned zero property law today. If you notice, there's none. It's all Fifth Amendment stuff. Justice Thomas is a self-professed originalist, and as such, he doesn't have a strong sense of stare decisis. If he thinks a precedent's wrong and not consistent with the Constitution's original public meaning, as it would have been understood at the time it was drafted, he will overturn the precedents. He says, get rid of Berman, get rid of Hawaii Housing Authority, and public use means public use. That is, it can be used by the public, which I think makes sense. If it's a hospital or a train station or a school or a park or some sort of government building that anyone in the public can use, it's public use. If I try and walk into a Pfizer research facility, like I almost did, right, and almost get arrested, you can't use it for the public. So he would simply limit the phrase public use to public use, not public purpose. That's part 3 of his opinion. I also give you part 4 because it, I think, conveys an important story. The taking in Berman, right? He gives some numbers on this. This was a predominantly non-white neighborhood in the 1950s. And following World War II, governments throughout the United States used eminent domain in a fairly specific fashion, which was to root out African-American neighborhoods, mostly in inner cities. And you use eminent domain to basically take people's property and say, go move somewhere else, and they really can't. This was very common. And Justice Thomas walks through some of this history. And he connects the use of eminent domain to a famous footnote, which I'm sure you studied, which was footnote 4 of Caroline Products. And footnote 4 of Caroline Products says that when the government restricts a provision of the Bill of Rights, that there should be heightened scrutiny. And that when other aspects of the political process focus on the discrete and insular minorities, there should be heightened scrutiny. And for Justice Thomas, this is an easy case, right? Where you have literally an enumerated right, Fifth Amendment, and you have these takings which usually fall on minorities, that the court should have heightened review. But instead of giving heightened review, the court gives a rational basis scrutiny, where they don't want to look at any contrary evidence that might show an improper purpose behind the taking. Right? Justice Thomas writes that there's a predictable consequence of the court's decision, and it'll simply exacerbate this sort of takings. And this is the reason why you have, again, Rush Limbaugh and Jesse Jackson on the same side of the issue. You have groups from across the spectrum following briefs in this case saying this will hurt lots of people. And indeed, the decision, I think, or at least perhaps in the short term, did. Okay. Okay. All right, so any other questions on Justice Thomas's dissent? Any questions on the Thomas dissent? So let me talk a little bit what happened after Kelo. Again, Justice Stevens mentioned in his opinion that, if this is a really big problem, then states can fix it themselves, which again is an unusual fashion for the court to discuss it, because court will usually say it's the federal constitution that provides the floor, not the state constitutions. By 2007, 42 states had passed some form of eminent domain reform. Some were stronger than others. Generally, the stronger ones were proposed by a citizen ballot, and the weaker ones were proposed by the legislature, which is not very surprising. And again, Texas has one called Amendment 11. It's not very good. Okay. Any questions on that? All right, so let me summarize a bit. Our topic today focused exclusively on when a use of eminent domain is for a public use. Our topic for the next 3 or 4 classes focuses on something else. What happens when you keep your property, but the government tells you to use it? So for example, the government says, well, you have to put a cable on the side of your house, or we'll take some of your raisins that you grew on your farm, or we'll tell you that you can't mine coal under your ground, or the government says you can't build a tower above your house, right? These are cases where you keep your property, and it's a discussion of, do you have a taking or not? And that's the rest of the semester. All right, any other questions? I'll see you all on class on Wednesday. Thank you.